This is Victor Abafe with A Healthier Democracy. And today, I want to talk about a case called Physician Hospitals of America v. Sebelius. Now, before 2010, according to the Stark referral laws, a referring doctor could obtain Medicare reimbursement for medical treatment given in a hospital in which a doctor had physician ownership in, as long as the doctor's ownership was in the hospital as a whole and not a specialty unit of the hospital. However, Section 6001 of the Affordable Care Act changed the Stark laws so that hospitals that were built after 2010 with physician ownership interests could no longer receive Medicare reimbursement. The Texas Spine and Joint Hospital, a physician-owned hospital in Tyler, Texas, and the trade group Physician Hospitals of America challenged the law in federal court. They argued that the law violated the due process and equal protection clauses of the Constitution, and the law was unconstitutionally vague. The Department of Health and Human Services argued that under the text of the Social Security Act, all issues that arise under the Medicare governing law has to go through an administrative process and be presented to the HHS secretary before it could be brought to federal court. This process was upheld in a case called Shalala v. Illinois Council. The hospital countered that their claim met one of the exceptions to the channeling process because the process would effectively deny them judicial review unless they invested millions of dollars in facilities that could be deemed unusable depending on the way the court ruled. In August 2012, Fifth Circuit Judge Leslie Southwick held that the hospital's claims have to go through the administrative process before obtaining the subject matter jurisdiction to be able to bring their constitutional claims to federal court. The court further stated that there was no prevention of judicial review because other hospitals could also bring in administrative claims. As a result of this decision, advocates of physician-owned hospitals have shifted their efforts away from the courts and towards the legislative arena. They argue that physician ownership improves physician autonomy and freedom and lowers the amount of bureaucracy associated with receiving medical care. In fact, a 2019 study found that for the 20 most expensive Medicare conditions, physician-owned hospitals save 8 to 15% per patient compared to traditional hospitals, which would save Medicare a bit over $1 billion a year. Opponents, though, state that physician-owned hospitals are able to cherry-pick healthier and better-paying patients and can avoid emergency care responsibilities, which leave community hospitals to shoulder higher-cost, life-saving services with thinner margins. The laws that govern who can own and be reimbursed for owning hospitals has a large impact on the quality and access to healthcare in America.